morning, Counsel, yes.
Good morning. May it please the Court, my name is Melissa Johnson. I'm an Assistant DA from Middlesex County. I'm here on the Commonwealth versus D case. I will be arguing the statutory issue. My colleague from Berkshire County, John Basset, is here on the Kiefner case, and he will be arguing the motion to suppress issue after me. Your Honors, this arises from a reported question under Rule 34, and the Commonwealth submits that the answer to that question is that possession of marijuana with intent to distribute is still a crime after the enactment of 32L, regardless of the amount seized. And that's based on the rules of statutory construction, it's based on voter intent, and it's also reinforced by this Court's opinion in Commonwealth versus Cruz. First, Your Honor, the statutory construction issue. The new Act, 32L, actually states that the Act cannot be interpreted to repeal or modify laws concerning the selling of marijuana. Now, Section 32C, which proscribes the distribution and intent to distribute marijuana, is a law that concerns the selling of marijuana, and therefore, under the plain and unambiguous language...
Well, how do you reconcile the law that says possession of an ounce, of less than an ounce, is no longer a crime?
Your Honor, there's actually several ways to reconcile that. The first way is that the possession of marijuana is actually codified in Section 34. That section was expressly amended by the Act. The Act actually had in Section 5 of the ballot initiative that it would be amending Section 4, the simple straight possession statute. However, there were no proposed amendments to Section 32C, which is the distribution and intent to distribute statute.
But why wouldn't the word distribution be used instead of sell? Is there a statute that proscribes the selling?
No, there's not, Your Honor.
So what would, doesn't that have to be given some meaning?
It certainly has to be given its common sense meaning, yes, Your Honor.
But common sense, selling is not the same thing necessarily. I mean, distribution is a much broader concept than selling, at least, for example, because some of the decisions have recognized that people can be prosecuted for transferring without selling. You know, somebody just passes marijuana to a friend.
Absolutely, Your Honor.
And would that still be a crime on your analysis?
If they passed marijuana
without any, without compensation of any sort.
Distribution, yes, Your Honor.
That's distribution, but is it sale?
It's not sale, but it is distribution, and distribution is still prescribed by the statute. Now, in Commonwealth versus Cruz, the Court said specifically in footnote 13 that distribution is still a crime. It is still a crime, even though the Act is saying laws concerning selling. Nowhere in Chapter 94C is the word selling used.
Can I just ask for clarification then? So you're suggesting that if you've got under an ounce and you're using it yourself, and then you're sharing it with someone whose possession also would not be anything but possession, that the combination of the fact that you each have done nothing wrong, but because you've shared, you've now committed a crime?
I am not, Your Honor, actually, and I'm glad that you brought up that scenario, because the scenario that you've brought up actually is talked about in the Commonwealth versus Johnson case, and that's a case where you have a situation where people are smoking marijuana with someone at the same time. And Johnson says, and that's 413 Mass 598, that the simultaneous and joint acquisition of marijuana for your own personal use, and you intend to share it with another person or with a group of people, that is considered only simple possession. So we still have that doctrine in place when you're talking about the scenario that you've just described. So in that case, it would not be criminal activity. It would be simple possession, assuming that the amount of marijuana involved in there is under an ounce.
So how would it work practically? You come upon a group, as it was in that case. I think they were sitting in a circle and there was something in the middle, right? So the only time that you can't arrest for probable cause is when you actually see a joint use of the joint?
Well,
Or-
you'd have to have facts, it seems to me, that would suggest some activity that was more than possession and more than sharing, and that
Yes.
basically is an intent to sell. I mean, we
Yes.
use the word distribution, but as a practical matter, it seems to me that what you're really looking at is an intent to sell. That's what's involved.
Absolutely, Your Honor. It is an intent to sell. The distribution and selling have been treated the same historically since the early 70s when the statute was amended. But I want to point out what is the most compelling part about this case is when I was talking about the two sections, the Section 34, which is the simple straight possession, and Section 32C, the Act only expressly amended Section 4, but left 32C alone. And that goes really to the intent of the voters and what information they had before them when they decided to vote on this ballot initiative. They had no indication that that distribution statute would somehow be automatically modified by their passage of the vote. So now they're left with the defendant's interpretation, which essentially creates a loophole that the voters had never endorsed before.
Well, focusing on Justice Botsford's question then, the practical consequences of your proposed interpretation, do you need then something more than the allowed amount of less, which is even in separate baggies for easier rolling perhaps, for personal use? It's presumptively for personal use. So you need something plus?
And yes, I do agree with that. I believe Commonwealth versus Cruz does make that point, that that odor of burnt marijuana by itself is not going to be enough. So, for example, in footnotes 14 and 15 of that opinion, this court goes on to give some examples, the packaging, any kind of paraphernalia, a scale perhaps, anything that might be indicative, or even the odor of fresh marijuana that could be indicative. And what that suggests is those accoutrements there are suggestive of criminal activity, which may implies that possession with intent to distribute is still a crime in
May I
Massachusetts.
interrupt you? So if you have to have some indicia of more than just possession, does that mean that the police are not able to search until they have indicia?
That's a great question. I think Cruz really talks about that particular issue. If all they have before them is the smell of burnt marijuana, that's not going to get you so far. But if there are other indicia that are immediately in plain sight, then those accoutrements, that indicia is evidence of perhaps a possession to intent, which is a crime, as this court has implied in Commonwealth versus Cruz. And then you can go on from there to perform a search based on reasonable suspicion of criminal activity, because possession with intent to distribute, regardless of the amount, is still a crime, as suggested by these footnotes in Cruz. In fact, in Cruz, in footnote 25, Your Honors, this court talks about the ramifications of this decision on personal use versus distribution. And the court said that basically persons who illegally possess marijuana for personal use only will take care to restrict their possession of that drug to 1 ounce or less.
So if a police officer sees a group of people sitting around a campfire and they're passing a joint around and he can smell their marijuana, there's nothing he can do about that because that is, in a sense, shared possession. But if he sees the person who had supplied that joint, that whatever it is, reach into a purse and take it out and then give it to somebody who then gets up and walks away, that's distribution.
Well, Your Honor, I still think that the Johnson doctrine could apply to that. Certainly the jury would be instructed because they would have to determine whether this marijuana as a whole is being jointly and possessed, with really the primary issue here being personal use and intent to share for others to enjoy for their personal use. So I do think that Johnson doctrine would apply, or at least the jury would be instructed in that situation. As to that issue, I can see that my time is coming to a close.
One more question. What if we simply interpreted the intent to distribute to be more than 1 ounce, that it's a crime to intend to distribute more than 1 ounce of marijuana?
Your Honor, I think that would effectively be a rewriting of Section 32C, which is not what the voters intended here. They did not want that section amended by the very express language
How
of
does that
the
differ
Act.
from your sharing? I mean, you say it's okay to share less than 1 ounce, but that's in keeping with the spirit of the statute. But it's not okay to say, okay, now you must intend to distribute more than 1 ounce. I don't quite get why one is okay and one is not.
Saying that.
Your Honor, I don't believe that's what I'm saying, but I do want to just point out in terms of the statutory construction and the voter intent is that division between personal use as described in 34 and distribution and intent to distribute, which was not amended by the Act. The defendant has no answer to that question, why that Act did not amend that. And that is because the voters did not intend. They did not want a situation where drug dealers were encouraged now to carry less than 1 ounce on their person, no matter how it was packaged, no matter how much paraphernalia, did not want that person to be standing on a street corner with up to 50 marijuana cigarettes, whether he was going to sell them or whether he was going to give them away. Either way, that is not what the voters intended to be decriminalized, not that behavior. If there are any further questions, I would rely on my brief, and thank you.
Thank you, Counsel.
Thank you.
Good morning. May it please the Court. John Bossé for the Commonwealth, Berkshire District. The Commonwealth respectfully requests that this Court reverse the motion judge's decision on the motion to suppress as well as the motion to dismiss. The Commonwealth wrote its brief prior to the Cruz decision. However, our case differs from Cruz in the sense that we have a named citizen who contacted the Great Barrington Police and informed them that there was a group of people smoking marijuana on our property.
But why does that get you anywhere, though? So the police officer knows that there's a group of people smoking, and the woman pointed to this defendant.
Right.
So?
Well, they also had personal knowledge that he arrested the defendant back in 2008 for drug charges.
That gives you probable cause?
We do. We
That
believe that.
alone?
Yes. That there's a probability that marijuana will be found on the defendant's
More
person.
than,
How much marijuana?
It's Commonwealth's position that the upon probable cause that the individual has marijuana on them, that they can search. Again, 32L only affects the penalty for 34. It doesn't say anything about search and seizure.
So your position would be any person who's ever been convicted of possession of marijuana, then the police could search if they came upon them and there was marijuana present, because they have probable cause.
Correct. If they have knowledge that
In the past,
in the past that they've been arrested for a drug offense, as well as the fact that in this case a named citizen reported that they were smoking marijuana on our property, and only a short time period elapsed between the officer receiving this information and searching the defendant. In Cruz, the driver stated that he was smoking early in the day, so the smell could have been lingering for quite some time.
yes, but that's the issue in Cruz is whether the smell itself is going to be some sign that there is more than an ounce of marijuana, right? What's the evidence here there's going to be more than an ounce of marijuana on this man?
Well, it is very difficult to establish that he had more than an ounce, but again...
I mean, where's the probable cause? I mean, you're rewriting Cruz, aren't you?
Well, again, our facts differ from Cruz, so again, the fact that a short time period goes by and the knowledge that the defendant had a criminal record for drug offenses.
you're not suggesting then that you do the search and then whatever you find supports whether or not there was more than an ounce after the fact.
Yes, Your Honor, I would be suggesting that, again, because Section 34, the simple possession statute, was only amended for purposes of the penalty. It was never amended for purposes of search and seizure. I don't believe we can take away the discretion of the officers to search. Essentially, it would be overturning, I think Commonwealth v. Bartlett say that upon a car stop, an officer is not required to ignore.
Well, your sister was saying there should be some indicia of more than just straight possession. And here you would say the indicia there was no indicia other than the prior conviction.
Correct.
That the officer was aware of.
But there was also a group of individuals, so also that there could be an inference that he was sharing the marijuana with these other individuals who were on the property.
Well, that would be somewhat speculative, wouldn't it?
Yes, Your Honor.
So your view is that if they were sharing, which, I mean, is that in conflict with the other DA's view? Your view is that if somebody observes the marijuana cigarette being shared, that would give probable cause, even though there's no evidence to believe it's more than 1 ounce?
Yes.
So you disagree with Ms. Johnson on that issue? You say that the Johnson case does not carry this far so as to prohibit.
Under the law, I would say that the police do have a right to charge whether or not they decide to. For example, if there's a Boston police officer down the street at the Boston Garden at a concert, whether or not he'll decide to charge an individual who's...
But you say, apart from whether or not you ultimately choose to prosecute, that it is that the sharing of marijuana is a crime and is the crime of distribution.
That's correct.
So you view
regardless of weight.
So you disagree with Ms. Johnson on that issue?
Yes.
Your time is up. Thank you.
Thank you.
I'm David Skeels. I represent Mr. Kiefner. However, I will be talking on behalf of both of the defendants because we do have an issue that overlaps possession with intent to distribute issue. Mr. Kiefner's case, the judge in the lower court did allow both the motion to suppress and the motions dismiss. The prosecution argued on the same theory in Kiefner that was eventually rejected by this court in the Cruz case.
Well, on the motion to suppress.
On the motion to suppress, that's correct. Not on the motion to dismiss, just on the motion to suppress. There was no evidence Mr. Kiefner had committed a crime. The police received a report he'd been smoking along with some other people in the yard of a private residence, and they went there. Mr. Kiefner was pointed out to them, and they immediately searched him without any threshold inquiry. And I'd suggest...
Just let me ask you this. So
Right.
a police officer approaches someone
Right.
who someone has just said they're smoking marijuana in my
Right,
front
right.
yard. All right, so it's not a criminal offense. What can the officer do? Because the marijuana is subject to seizure.
Well, he can give the person a citation.
And say, turn over the marijuana, please?
I don't know about that, but I think that under the statute, what is contemplated is if he sees the person actually smoking, he can give him a citation. Now, normally you can't arrest somebody or search somebody simply because they've committed a misdemeanor unless it's committed in the officer's presence. And in this case...
But they've got evidence that he's got contraband,
Right.
which is subject to seizure. Can't he just say, turn over the marijuana, please?
Well, that's not what happened in the
No,
Keefe
I'm just-
case. He's actually searched him, and I don't know that he could. I'd suggest I don't think he could just say turn over the marijuana.
Why not?
Well, any more than he could say turn over the gun that I think you have, or any other contraband that he thinks the person has. I don't think that normally the police do not have authority to arrest somebody or search somebody simply for a misdemeanor unless it occurs in their presence.
No, it was not a search, just if he, but anyway, they move.
Yeah, that would be our position. And in this case, he was actually searched.
Right.
And I'd suggest that is what the Cruz case condemned.
So you're saying that what a police officer should do is just write a citation out?
That's my
And that's
understanding.
it.
That's my understanding what the statute now says, that the police officer writes the citation, gives it to the defendant, and he will be subject to a fine, but or civil procedures, but not to arrest, search, or criminal proceedings.
Let me ask you a different question. I just want to see what the limits of what you're arguing are. Suppose a police officer is driving past and sees somebody taking a $10, a dime bag, and
Right.
Getting $10 for it,
Right.
and can witness all of that. Can the police officers stop and search for more? That's one question, but
Right.
the other question is, that certainly looks like a sale,
Right. Right.
and there's nothing in the statute that says that sales are exempt.
Right. I agree with the prosecution. The statute did not exempt sale of less than an ounce of marijuana.
So you're agreeing that for that, that's an arrestable offense?
That is under the statute. The statute specifically says, unless specifically accepted by the Sensible Marijuana Act, possession of an ounce or less is not a crime, but they specifically accept selling. So I agree with the prosecution. If a person has possession of less than an ounce with intent to sell, that's a crime, if it's intent to sell. But the prosecution is arguing intent to distribute was not abolished by the law. But that's not what the statute says. I think most of the voters would have believed when they voted for this initiative that somebody who has possession of less than an ounce of marijuana who intends to share it with his friends is not guilty or shouldn't be held to the same criminal penalties, should not have the same criminal record as somebody who's selling it or possessing it with intent to sell. That there should be a distinction between people who merely intend to share a small amount of marijuana with their friends and people who are actually selling the marijuana, who actually are...
So it's okay to give it away, but you can't
That
charge
I
for
would
it.
suggest that that is what the statute was intended to do. That's the specific language of the statute.
The 32C doesn't even mention sale.
32C.
It's possession with intent to manufacture, distribute, dispense, or cultivate. That's
Yes,
the crime. It doesn't
and
mention
that's
sale.
a Class D substance. And I would suggest that under the Sensible Marijuana Law, that must now be read as holding that if a person intends to distribute more than an ounce of marijuana, that's still a Class D substance. However, and if they intend to sell less than an ounce of marijuana, then it's still a Class D substance. However, if they intend to distribute, purely distribute, less than an ounce of marijuana, that is not a Class D substance. And my authority for that would be, first of all, the statute itself begins by saying, notwithstanding any general law to the contrary. That's an express repeal of any part of the general laws which, in fact, may conflict with the new marijuana statute.
Yeah, but shall not be construed to modify existing laws concerning
Say it.
the sale, manufacture, and this is the law 32C, which concerns, well, it doesn't even mention sale, but it concerns, it's the statute used to prosecute sale
yeah,
and manufacturing.
And can also be used to prosecute people who merely intend to distribute.
But
yes.
isn't it, but when you're dealing with a search question, it's you're before what is needed to prove the crime.
Right.
If an officer has evidence that the person intends to distribute,
Right.
and, I mean, whether that distribution is to share with my friend
right.
or to sell, at that moment in time, I'm not sure wouldn't give the officer probable cause if there's evidence suggesting distribution.
Well, in the
or an
Kiefner
intent
case, the judge found there was no evidence of intent to distribute.
Well, but that's because you can't use the stuff after the fact. No, I understand that. But let's just assume, for argument, that you get to the things that came out, that the cell phone and the messages,
right.
et cetera, were there, and there wasn't a question about what happened first.
Right.
That's available to the officer.
Right.
Would you say that the officer couldn't charge, maybe may not be able to prove it,
Right.
but couldn't charge the person at that point?
Well, if he's charging him with intent to possession with intent to sell, that's still, as I agree, that's still a crime. That's
I mean,
what the
but the
statute
crime
says.
would be possession with intent to distribute, because that's what 32C,
Well,
that's the language that 32C uses.
However, the new sensible, well, 32C uses that language, but it says possession with intent to distribute a Class D substance. A Class D substance under Section 31 is defined as marijuana unless it's otherwise accepted. So marijuana under the new marijuana law, less than an ounce of marijuana is accepted from 31, Section 31. It's no longer a Class D substance under 31. So they can prosecute for possession with intent to sell less than an ounce, and they can prosecute for possession with intent to distribute more than an ounce, but they cannot prosecute for possession with intent to distribute less than an ounce, or an ounce and less. That
Distribute meaning
not
for
only
money.
distribute includes sale and share. And a prosecutor who is prosecuting a case possession with intent to distribute can argue to the jury, we're not claiming the defendant intended to sell it. We're merely claiming he intended to share it with his friends.
Ms. Johnson says no to that.
And well, I suggest that was one of the main things that the voters wanted to abolish when they passed this statute. They didn't want people who are merely sharing marijuana with their friends to have the same criminal record as somebody who's selling it, or they didn't want someone who is to be subject to the same criminal penalties. Under the present law, the judge would have to, or the prior law to 2008, and between 1971 and 2008, the judge would have to instruct the jury to find the defendant guilty of possession with and distribute. You don't have to find he was intended to sell it. You can simply find that he intended to share it with his friends. And the jury, if they feel that he intended to share it with his friends, is going to have to find him guilty. And the judge is going to have to sentence the same type of sentence that is now applicable to people who are
We don't have
selling.
to answer this case, we don't need to answer that question, do we?
Well, I think you do, because if distribution means something other than intent to sell, yeah, then it
But
includes...
on your facts, just on your facts, you would say there's nothing to indicate anything but possession. There's nothing, I mean, at least my memory is that all we have is the source of the information.
Right.
Saying he was smoking.
Right.
We don't have any sharing of anything.
Right. As far as the search goes, all the officer knew was that he'd been smoking marijuana cigarettes. So they didn't have any evidence that he committed a crime, that he was going to sell it, or anything like that when they searched him. And that's why the judge allowed the motion to suppress. The judge said even if possession with intent to distribute is still a crime, there's no evidence of that even happening. There's no evidence of even...
Can you think of a hypothetical situation where police would be able to search someone? Give me, there must be a hypothetical where...
Well, I think one that Judge Link mentioned, where they see him actually giving a small amount of marijuana to somebody and in return for a $5 bill. If somebody passes a cigarette to somebody else, marijuana cigarette, and receives $5 in return, and the police see this, then they probably could arrest for possession with intent to sell. But if they merely see somebody passing a marijuana cigarette at a party, they see people passing a marijuana cigarette at a party, they shouldn't be able to arrest the whole party on the theory that everybody in that party intends to distribute marijuana. That is what the statute wanted to abolish, to get away with, because this is an expensive business. In Kiefner's case, he was arrested, he was brought into court. The cases had to be processed in court. In the D case, because the police officer smelled marijuana in the backpack, case has to go to court. Somebody's going to file a motion to suppress. If that's allowed, the prosecution is probably going to appeal to this court. If it's denied, the defense is going to appeal to the appeals court. And it's not only the police that have to spend time on this sort of thing, but the courts do. And in a time when everybody is having their budget cut, this is something that should be liberally construed. This statute should be liberally construed to carry out the voters' intent that the police and the courts not get involved in in punishing the recreational use of marijuana, the same as they would be punishing commercial sales of marijuana, whether they're less than an ounce or not. I suggest that was the intent of the voters, to do away with the police. After all, have a duty to enforce the law, even if they think it's stupid. If they don't enforce the law as they understand it's written and has been decided by this court, then they're going to be subject to criticism. The courts are going to be subject to criticism if they don't enforce the law. And I suggest that's what this initiative petition was meant to do away with, with cases in which people are merely using marijuana on a recreational basis. They're passing it around in a party or something, having a cigarette at a party or something of that nature, but not to do away with prosecution of people who are selling marijuana on a commercial basis.
So if you are right, let me make sure I understand this. If you are right, the police may still prosecute somebody for the possession of a small quantity of marijuana, less than 1 ounce, as long as they have an intent to distribute more than 1 ounce?
Well, I don't know if they intended to. I think it's intent to sell is the way the statute is written. The statute.
Certainly, if you possess. So you're saying that the possession must be more than 1 ounce, because generally you can have a possession with intent to distribute, but does not relate to the amount in possession.
Under the new law, if you have possession, if the new law doesn't abolish possession with intent to distribute more than 1 ounce, but it does abolish intent to distribute less than 1 ounce if you're not if you don't intend to sell.
Okay, but in your case, if it were cocaine and not marijuana,
right,
and if I don't know what the text message says, but let's assume the text message makes it strong evidence that he intended to distribute the drug,
right,
then you would say that regardless of the amount at issue of possession, it may still be prosecuted for a possession with intent, and you may intend to distribute much more than you have in possession.
You can still be prosecuted for possession with intent to sell, but not for possession with intent to distribute if it's less than 1 ounce. If the distribution doesn't involve sale, I think every distribution does involve a sale. Every sale involves a distribution. So you can always be prosecuted for distribution if you're guilty of selling. But there is a group of people who have no intention of selling, but do have possession with intent to distribute. The people intend to share with other people. And right now, that's, as I understand it, under the appeals court's decision in the Lawrence case, that's a crime. If the defendant admits to the police, I intended to give it to my friends, I wasn't going to sell it, he's guilty.
So you're rejecting this broad interpretation of Commonwealth versus Johnson that's been proposed?
I think that's a case where a joint possession case, where people, in fact, all get together and buy the marijuana together. But I believe that if just one person buys it and he intends to share it with his friends, that he wouldn't be protected by the Johnson case. That's my understanding of the law.
Thank you, Congressman.
My time is up.